Welcome to the first installment of Reflections, what we hope will be an occasional series of conversations that draw on the research and expertise of the faculty in the government department at the University of Texas at Austin. We're going to use this time to reflect on some of the issues of the day, and today it's reflections on impeachment from the perspective of two lifelong experts on the Constitution of the United States. My name is Dan Brinks, and I have the privilege to chair the truly excellent Department of Government here at UT. My own research is in comparative law and politics. I teach in the government department and the law school, and I focus mostly on issues related to law and democracy in Latin America. Sometimes I look at other parts of the world, but the bottom line is that I'm not an expert in the topic we're going to talk about today. The experts are here with me. Jeff Tulis, all the way to my left, is a professor in the government department. He writes and teaches on the presidency and on American constitutional development and constitutional theory. He has written books like Legacies of Losing in American Politics, The Rhetorical Presidency, and most relevant for today's discussion, he wrote a chapter on impeachment in the book The Constitutional Presidency long before this impeachment was in the air. Gary Jacobsohn is also a professor in the Department of Government. He also teaches at the law school. These days, he writes primarily about comparative constitutionalism, but he has written on the U.S. as well. He has a couple of recent books like Constitutional Revolution and Constitutional Identity, but the books that he's written that reflect on U.S. constitutionalism are Apple of Gold, Constitutionalism in Israel and the United States, The Supreme Court and the Decline of Constitutional Aspiration, and Pragmatism, Statesmanship, and the Supreme Court. As you all know very well, impeachment is in the news and in public and private conversations everywhere, so I thought today we would take up three questions that seem to be at the core of what we're thinking about right now. First, how should we understand the role of impeachment in the context of our Constitution? Second, what are the rules for impeachment, including the $64,000 question, what is an impeachable offense? And third, if we get to it, what might happen if an impeachment succeeds and goes all the way through to the Senate? So let's take that first question up first. How should we understand impeachment in the context of the Constitution? Isn't it strange to have a Constitution that sets up a democracy in which elections elect presidents, and then to have a clause that potentially could undo that election before the next one even comes up?
It is, and it strikes a lot of people as strange. You've sometimes heard people say that impeachment is a way to undo an election, but impeachment's actually woven into the whole fabric of the Constitution. It appears 6 times in the Constitution, not just in one clause having to do with the removal of the president, but in actually all the clauses having to do with the major branches of government, the Congress, the president, and the court. So impeachment's part of the whole separation of powers architecture. And so one way to begin is to suggest that it has something to do with how the whole polity works, not just the issue of whether some particular president has committed a crime, though obviously that's very important.
So do you think it really is undoing an election? How do you feel about that?
Well, I mean, impeachment is part of the constitutional design. And so, yes, it undoes an election only in the technical sense that the person who's been elected might eventually be removed from office through impeachment, but that is by design if an impeachable offense has occurred. Still, perceptions are important. And people will think, particularly in this partisan time that we're in now, that an unfortunate and perhaps improper reversal of an election has occurred. And this is something that was actually anticipated from the very beginning. Hamilton, in his Federalist number 65, said the following. It's worth thinking about. He said, "The prosecution of impeachment will seldom fail to agitate the passions of the whole community and to divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or another. And in such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. So the perception will be there, particularly in a partisan time, that once you pursue this, particularly if it is largely divided in strict partisan terms, that an election will have been improperly undone, even though the design of the Constitution, of course, suggests that that point is essentially a narrow political one.
So when Hamilton said that, what Gary just read, he was actually setting forth the problem that the Constitution was designed to try to mitigate. So that comes before his discussion of how and why the Senate was going to be the place to try the president. And his subsequent argument was that if that were properly designed, the kinds of issues that Gary's just raised would not be as prominent as people had feared. In fact, as Gary might be the first to suggest, we're actually witnessing what in fact he feared, which suggests that the Senate may not, over time, have worked quite as well as Hamilton actually anticipated and hoped it would.
Okay. All right, so anyway, we have impeachment at the center of the system of checks and balances and separation of powers. We have that it was clearly anticipated by the founders. We can see that they even anticipated some of the divisiveness and the bitter sort of factionalism that we're seeing in the news today. Did they at least lay out, a step-by-step process in the Constitution to make sure that everything was done orderly and in order? Did they set the courts to look over it to make sure things didn't get out of hand? What kind of process is in the Constitution for doing this?
Well, actually, very little is said about process, other than that each House has sole responsibility over, in the case of the House, actually engaging in the impeachment itself, and then the Senate has the responsibility of trying the person who has been impeached in the House. The word sole responsibility has suggested that there should be no intervention in whatever process is determined in each of the houses, which is to say, in its most extreme version, that the court itself must respect the sole responsibility of each House to set its process. And there has been some Supreme Court consideration of that issue in a case interestingly called Nixon versus the United States, not President Nixon. There was another case involving President Nixon, but a Judge Nixon who was impeached and then tried by the Senate, found guilty, and then he argued that his trial in the Senate was unconstitutional because it didn't conform to what he imagined the process that should be performed within the Senate. What happened is that the evidentiary hearing in the Senate was focused only on a small group of senators. Eventually, the entire Senate voted, but he argued that the entire Senate had to engage with the issues from the beginning. The Supreme Court, at least the majority of the Supreme Court, suggested that there shall be no judicial review of any determination or any process that has occurred in the Senate, respecting the idea that they have the sole responsibility. That is the precedent, but there were some concurring opinions which suggest that the court can't be totally indifferent to process. Suppose the Senate were to flip a coin to determine guilt or innocence. Should the Supreme Court respect the sole responsibility of the Senate to establish a process? Clearly, the court cannot be indifferent to process, even though due process, because this is not a criminal trial, is not necessarily a component of that trial. Nevertheless, there could be a time when a court, looking back on what the process was, could say, well, it just doesn't make it. But the controlling precedent now is that there is a demonstrable commitment by the Constitution to another branch of government to perform this task. Therefore, the court has absolutely nothing to say about it.
Well, to back up a little bit, one of the reasons a lot of Americans focus intently on whether the court should get involved to begin with is that they think of the impeachment and trial process as a criminal process. But they're not crazy to think that, because the House was set up to be analogous to a grand jury, and the Senate was set up to be analogous to a criminal trial. But the key word is analogous to, They were supposed to be sort of like that, but also different. And so the question would be, well, if they were supposed to be sort of like that, but also different, why? Why not just be a grand jury and a criminal trial? And the answer was that the design reflected an intention to make this a very high order of political decision, not an ordinary partisan decision, but a decision about whether the governmental architecture really wasn't working because of gross abuse of office or some sort of serious breakdown of public trust. And so in order to sort of induce that in politicians, they made it look similar to what we do in judicial proceedings over criminal trials, but actually be different than them. So the senators, for example, take a new oath from the one that they take as senators to reform. They're the same people, and they meet in the same room, but they take an oath to be a different kind of body. And that body is analogous to a court, and that court is going to sit in judgment over whatever charges are brought by the House. The charges that might be brought by the House are called articles, not charges. And the people that argue them are called managers, not prosecutors. So all these things are analogies to the legal process, but they're not the same thing on purpose so as to make it a kind of higher political process.
Okay. So I'm going to come back to that question in a little bit, but it seems to me the Constitution says treason, which is a crime, bribery, which is a crime, or other high crimes and misdemeanors, which also sound like crimes. Where did that language even come from if it's not meant to suggest that at least we're looking for a crime, that to see whether a crime has been committed before proceeding with the impeachment?
Well, there's no doubt that some crimes that would be crimes in the ordinary course of business, would be impeachable. It's also the case that if you're president of the United States, you might do something that would be a crime for an ordinary citizen that wouldn't be a crime for a president. So there's an overlap, in other words, between the crimes that count in our general understanding of what a crime is and what it would mean for a president to commit a crime. So when they first were wrestling with this phrase, they originally came up with treason, bribery, or maladministration. And there was a debate that might make our system too much like the British system, in which you could throw somebody out for a policy difference and a vote of no confidence. And so they wanted to find something that would capture abuse of office, but wouldn't just be that the losers get a second chance at throwing out the winners of a partisan dispute. And so they modeled it on the Hastings impeachment that had been going on in Britain. And the background to the Hastings impeachment was this notion of high crimes and misdemeanors, which was a technical term from 14th century English law, which meant abuse of office. In fact, there was no, what we mean by misdemeanors today didn't exist then. They had something called trespasses for what we mean by misdemeanors. So the bottom line is high crimes and misdemeanors was a technical phrase meaning abuse of office. Okay. And so they added that and they replaced maladministration with that phrase.
But I think the important distinction that emerges out of that historical survey is the distinction between what you might call low politics and high politics. And the idea of rejecting the notion of maladministration suggests that somebody should not be held impeachable for a policy that somebody disagrees with, that it should reflect a transgression not of a trivial kind, but of the sort that actually reaches to the ultimate principles within the Constitution itself. That to be dispositive for an impeachable offense, one has to engage in a political offense that actually reaches to the underlying principles of the Constitution itself. And again, to quote Hamilton here as well, when he spoke of impeachable offenses, he talked about those with a peculiar propriety that can be denominated political, and he used capital letters when he talked about political. I think that in itself is a visual representation of what it means to talk about high politics as opposed to low politics.
And low politics can include more than just a partisan dispute. So for example, there might be a bipartisan consensus that a president exercised poor judgment in some case. And that might not also rise to the level of an impeachment offense, but rather be something left for the polity to evaluate in the next election. Whereas a pattern of serious political misjudgment or an attempt to thwart the oversight responsibilities of Congress or to obstruct its ability to do that, those would transform ordinary politics into something higher.
So what we're looking for, I think, is something like a violation of the public trust. We put the president there to do a particular job that's defined in the Constitution, that's in accordance. They take an oath, right, to uphold and execute faithfully, and so on. And what we're looking for is something that has something to do. Can you say more about that? Can you give me maybe some examples to try to flesh out what might be an impeachable offense?
Well, if a president, for example, consulted their advisors, submitted reports and so forth to Congress as normally expected, but made a terrible mistake in judgment with respect to, say, troop decisions or whether to intervene in international conflict, that would not necessarily be an impeachable offense, and probably would not be, even though it might have been a big mistake for the country. If, on the other hand, the president repeatedly thwarted the will of Congress on the same thing, whether or not the judgment itself was good, would be a big problem and would be potentially an impeachable offense.
And that's because it violates the principle of separation of powers and checks and balances, and so it's essentially something about the architecture of the Constitution.
Yeah, the architecture is important. Some offense that constituted a real attack, assault on the actual integrity of the very processes of government, and you can imagine what those might consist of. Certainly exercising one's delegated power, and after all, the Constitution delegates power to the various branches, including the president. Under Article 2, the president cannot do whatever he or she chooses to do. He can only exercise delegated powers, and if he uses those powers for personal gain, for example, as opposed to pursuing the national interest, one could at least begin to engage with the argument that an impeachable offense has occurred.
So it's not just, okay, this president did something that was not part of those delegated powers, but also if the president is using some of those delegated powers for an improper purpose, in violation of the public trust, for example, right, for reasons that are not in the public interest or something like that. They're broadly defined, I guess, right, because that often would be sort of in the eye of the beholder to some extent, wouldn't it?
Well, broadly defined to be sure, because the powers of the executive are somewhat broadly defined. They are not confined to a specific express list of delegated responsibilities. So there's always going to be contention about what is an abuse of power. And that's why we have this process. Unfortunately, when it becomes too much of a partisan process, we don't really fully engage with the issues perhaps as they should be. But ultimately, when those issues are raised in that form, one has a conversation and ultimately a debate about whether there has been a violation of the public trust.
So presidents do have enormous power as delegated by the Constitution. And one example of that is the pardon power, which is thought by many to be virtually unlimited. The virtually is important, however, because there's an exception. For example, you can't pardon somebody for an impeachment charge. And that might be interpreted also to mean that you might not be able to pardon other people connected with an impeachment inquiry, though that hasn't been litigated. But the point is that the president has enormous power that is expressed in the vesting of the executive power in the president, but also is expected to take care that the laws be faithfully executed. And those two things have to be sort of put together. And impeachment is a kind of signification that there is a real concern that the laws are not being faithfully executed. And so some case is being brought to make that argument.
But what does it actually mean to not faithfully execute the laws? For example, suppose a president succeeding another president who has implemented a policy, let's say health care, and the succeeding president disagrees entirely with that policy and refuses to invoke what's necessary to actually enforce that policy. Would that constitute an impeachable offense? Probably not, but you could at least have a debate about such a thing. There's ambiguity surrounding the whole process. The first article of impeachment in the Clinton impeachment was that the president had undermined the integrity of the office. What does that mean, to undermine the integrity of the office? That could extend into a whole range of domains that are almost by definition controversial, but one has to imagine that such an offense could be impeachable.
So we have a political standard in a way, right? In Hamilton's own words, we have a sort of loosely defined process that is charged to each of the institutions that are taking part in the process, and we have a series of standards that are quite open-ended. They're more principles than rigorous sort of lists of checklists that we could use to decide. So isn't it dangerous in some ways to say, look, this is really a purely political process. It's a purely political standard. Even if you add the qualifier, it has to be high politics, right? What sorts of safeguards, what kind of procedural or other safeguards do we have to make sure that it doesn't turn into, as you say, just a vote of no confidence, a disagreement over policy?
So the danger goes in both directions. You could have the danger that you're actually asking the question about, which is that people start to use the power that the House has just to get back at political enemies, and if they control both houses of Congress, to just throw out people they don't like. That's the sort of slippery slope danger in the direction of unmasking this as a political process and people losing the distinction between high and low. Over the course of American history, I would argue the opposite danger has happened, which is that we've over-legalized the process, starting with Andrew Johnson. We've thought that presidents could only be impeached for crimes that were crimes for ordinary people. And so, for example, we wouldn't necessarily impeach a president under this view for saying things that really tore the country apart verbally, but didn't seem to violate some criminal statute. So the 10th article of impeachment for Andrew Johnson was for just that. He gave lots of speeches that were very much similar to, say, Trump's tweets and rally speeches, for which he was impeached, but not convicted. It was dropped at the Senate trial. And the argument that they used to drop it was, that's just opening the door to politics. In fact, that charge was more viable than the one that they invented instead of talking about his obstruction of Reconstruction, which was that he had fired the Secretary of War, and they had invented a law saying he couldn't do that. And he had good constitutional arguments that he could. So they attempted to find a legal way to get rid of him for a genuinely political problem. And ever since that time, presidents have relied on that. Clinton relied on it because he tried to show that he didn't commit perjury, whatever his actual public lies may, that he publicly lied, but he didn't necessarily commit perjury. And Nixon tried to do the same thing by suggesting that he may have done some mistakes, but he didn't violate actual laws.
So
Yeah.
what would you think was Clinton's impeachable offense? You could say he committed perjury, or allegedly he committed perjury, and if you could establish that fact, as Jeff was saying, that under this notion that has taken root that you have to have some kind of a criminal dimension to a real impeachment, that would be the basis for the impeachment. Or was his behavior such that it, again, as the Article 1 in his impeachment proceedings suggested, that he undermined the integrity of the office. I suspect most people who viewed that impeachment, and one can imagine the same thing going on today, would look at the behavior of the president as somehow inappropriate in the large sense that it called into question his commitment to the responsibilities of office.
Right. So however you came down ultimately on that question, the focus should have been on the behavior in the Oval Office rather than his behavior at a deposition where he's parsing words
exactly.
or whatever.
And today that debate might have been more robust after the Me Too movement than it was at the time that he was charged.
So there is one procedural safeguard in the Constitution. This 2/3 requirement of, for conviction in the Senate. Right, so 2/3 of the senators would have to agree, and in a two-party system like ours, in a way, isn't that a way to elevate the debate so that it does become about something higher than just partisan politics? In a way, if you're going to get a whole bunch of the opposite party to agree with you, in some way, you're going to have to persuade them that there's more at stake than just a policy disagreement or some mistake in judgment.
Well, one thing that does is in the trial, there's a large discussion, and the discussion is about how bad is this? And you could actually reach a conclusion that it's really bad, but it doesn't warrant removal from office, and that's why you don't get the 2/3 vote, and that could be a possibility. You could get a decision that it's really bad and it does warrant removal from office, but the Constitution also provides that you could be precluded from ever running for another office too, and they have a separate vote on that. And you might decide, well, we're not going to decide that question if the people really want this person. And so there's a series of steps. One scholar argued that, in fact, there might be a certain justice that attends to somebody being impeached even though they're not convicted, because there's a kind of public reckoning that raises public consciousness as to the seriousness of the alleged crime, but also a judgment that it doesn't warrant removal from office. But that didn't mean nothing was wrong. So there's you can think of the whole thing as a process of steps designed to sort of calibrate how bad it is what the president is alleged to have done.
All right, well, the time is almost up. So I thought I would summarize a little bit and maybe give you a chance to disagree with me if you think I'm reaching the wrong conclusion. I mean, I think first we talked about how impeachment fits into the overall structure of our Constitution. It seems odd because in a way it is a way of overturning the last election, but in a way, in a different way, in a deeper way, it's integral to the fabric of the Constitution. It's one of the elements that animates our system of separation of powers and checks and balances, and it's a way to ensure that the person we've put in such a powerful office actually carries out the powers of that office in the public interest.
Yeah, as we said, the separation of Justice Brandeis says that the separation of powers is what prevents us from having autocracy. Right. Impeachment is a guard against autocracy.
Great. And then it sounds like it should be a very legalistic affair. We often use legal-sounding language, and the procedures look vaguely legalistic. But as you said, it's an analogy, right? Not an actual criminal proceeding. And so it's actually about something deeper than the technical violation of the law, and it really requires us to elevate our debate above the ordinary debates that we have in what you've called low politics to something much deeper than that, something about the abuse of the powers of the office in violation of the public trust.
And to elevate the discussion from legal debates to a different kind of political discussion.
To a different and better kind of political discussion, right. And then something we really didn't talk about, but in a way, at the end of the day, it's not just an up or down vote on the president. There's a vote. You could have a censure that's short of removal from office. You could have a removal from office, but not the disqualification from ever holding public office again, or you could go all the way and disqualify someone from holding public office again. So we could, interestingly, have someone who's removed from office and then sort of submits the case all over again to the American people and says, do you want me back or not? Well, thank you for joining us on Reflections, and we hope you enjoyed it and learned something along the way.